right, we are here today for oral argument in case of Sabre Healthcare doing business as Bath Manor Nursing Facility versus David Hudgins. That's case number 29698. Each side will have 15 minutes in which to present your arguments. Appellant may reserve up to 5 minutes for rebuttal. If you do wish to reserve rebuttal time, let me know when you begin, just before you begin your argument. I will do my best to try to monitor that time for you. The arguments are being visually and audibly recorded to be posted online, as well as being live streamed as we speak. We have read your briefs and we are ready to proceed when you are.
Thank you. I would like to reserve 3 minutes for rebuttal,
Right.
Your Honor.
Okay.
Thank you.
You're welcome.
Good morning, Your Honors. May it please the court. My name is Amy Bachman, and I represent the appellants, Sabre Healthcare and Bath Manor Nursing Facility. The basic issue before this court this morning is whether Sabre properly and timely submitted its proof of claim to the estate of Opal Hudgins for care provided to Opal Hudgins at the Bath Manor facility during the final months of her life. This appeal arises from the dispute over a timely and adequately presentment of a proof of claim against the estate of Opal Hudgins in the Summit County Probate Court by appellants Sabre Healthcare and Bath Manor. The estate filed a motion to strike Sabre's claim, which the probate court granted, giving rise to this appeal. Sabre maintains that it did properly present its claim against the estate of Opal Hudgins pursuant to both the revised code 2117.06 subsection A1 and also the Ohio 2nd District Court of Appeals ruling in Children's Medical Center versus Ward. Sabre maintains that the presentment was proper because Ohio law does not require the claim to be presented in any particular form, that the presentment of the claim was timely made, that the failure of the administrator, David Hudgins, to either accept or reject that claim within 30 days constitutes a waiver of said objection, and that David Hudgins' actual knowledge of Sabre Bath Manor's claim satisfied the presentment of claims particularity and efficiency requirements to enforce its claim of debt against the estate of Opal Hudgins. This is a case of nuanced disagreements and veiled attempts to avoid payment responsibility, which began in 2016 while Opal Hudgins was living at Bath Manor and receiving round-the-clock skilled nursing care. Ms. Hudgins was admitted to Sabre's facility, Bath Manor, on October 27, 2016. David Hudgins was her attorney in fact upon her admission, and he signed the admissions agreement agreeing to pay for Ms. Hudgins' needs in his capacity as her sole fiduciary. Shortly thereafter, due to her incapacity, the Summit County Probate Court appointed David Hudgins as the guardian of both person and estate for Opal Hudgins on December 1st, 2016. At all times material hereto, David Hudgins, in violation of his duties as guardian, failed to qualify Opal Hudgins for Medicaid and refused to liquidate her primary asset, the home residence. Opal Hudgins was denied Medicaid benefits on April 4th, 2017 because she had an asset, the residence, that placed her over the program limit. At all times material hereto, David Hudgins was aware of the instant claim by Bath Manor because he was aware that Opal was receiving advanced medical care from Bath Manor. He was aware that he was not paying for said care, and since his inaction led to her denial of Medicaid benefits, he had actual knowledge that a significant balance would be due immediately at some point, which ultimately happened upon her death. Opal Hudgins died on March 16, 2018. On June 1st, 2018, less than 2 months after Opal's death, and while the guardianship was still open, I might add, Bath Manor presented notice of a claim against the estate of Opal Hudgins by mailing a computer-generated billing statement to David Hudgins, the guardian and now estate administrator for Opal Hudgins. Over 1 year after Opal's death, on March 25th, 2019, David Hudgins established the estate of Opal Hudgins with the Summit County Probate Court. Bath Manor was not notified of this estate establishment despite the fact that Mr. Hudgins was on notice for over a year of the outstanding bill that was presented to him on June 1, 2018, and despite the fact that he was well aware of that bill even prior to that because he was Ms. Hudgins' sole legal guardian.
Counsel, is there anything that would obligate Hudgins to notify Sabre?
His fact that he was materially aware of the
Legally, though,
outstanding balance.
is there anything legally, statutory, or case law that would require him to notify you?
Not that I'm aware of, Your Honor, but again, his actual knowledge is in his capacity as the fiduciary of her estate and her fiduciary prior to death.
Well, the statute says that claims shall be presented after appointment of an administrator. Was there a presentment of the claim at any point after Hudgins was appointed administrator?
There was, Your Honor, yes. On August 22nd, 2009, that claim was submitted, and that was when Sabre Bath Manor became aware of the estate having been set up and Mr. Hudgins being appointed. And at that point, that's when Sabre submitted a secondary claim to Mr. Hudgins. They did it first in June of 2018 while he was still in his capacity as guardian and the only representative for her. And then they did it again as soon as they were aware that he had set up the estate. In response to that,
excuse me, that was different than the confirmation of waiver that was submitted to the court? The August submission?
No, I believe they were submitted at the same time, is my understanding.
And to follow up on that, counsel, to follow up on Judge Teodosio's question. So what was submitted was a document that indicated that the fiduciary had previously waived his ability to dispute the claim?
Correct, because the claim had been submitted before.
But an actual claim was not filed with the probate estate, correct? I mean, you said they were filed together, but I'm a little confused about the process here, because it looks to me then what happened was, and I'm sure he can correct me if I am misspeaking, he filed a motion to strike that notice that he waived the claim. And then we have a judgment entry that says that the Bath Manor has no claim.
So on 8/22/2019, there is a correspondence that says a creditor's claim is returned. I don't believe that the docket actually lists the claim that was made. There is prior counsel on this case with my firm, Mr. Kulik, did submit, but it says they're not accepting the filing of the claim. So he did submit it, but it doesn't actually appear on the docket, is what I'm seeing from my review of the letter that was sent back to Mr. Kulik on 8/22.
Okay, and we'll have the record in front of us to review. I was just curious, as the oral arguments go forward, what exactly it is that happened based on the titles that they're given in the briefs.
Right. Sure. And I do understand that. Unfortunately, like I said, it doesn't actually appear on the docket because they didn't accept the claim. So it was submitted, but it was returned. It doesn't look like it was ever docketed, is how I'm reading it. So in response, David Hudgins filed a motion to strike on September 10th, and following a lengthy delay due to several procedural issues, Sabre Bath Manor timely submitted its motion in opposition on November 27th, 2019. David Hudgins replied December 9th. On February 10th of this year, Judge Marsh Stormer issued a final appealable order finding in favor of Mr. Hudgins and the estate and striking the claim from the record. Sabre Bath Manor timely appealed to this court on March 5th, 2020. Here, an appellate court reviews a probate court under a abuse of discretion standard, and that applies here. Sabre maintains that the probate court abused its discretion by narrowly construing revised code 2117.06, which sets forth the guidelines for presentation and allowance of a claim against an estate. And then in Children's Medical Center versus Ward, Ohio's second appellate district concluded that revised code 2117.06A1, which defines the presentment of claims requirements for creditors, is satisfied by a computer-generated billing statement that clearly indicates the creditor's name, address, and the precise amount of the obligation due, identifies the decedent as the debtor, and is timely received by the administrator of the decedent's estate. Sabre's position is that the probate court should have followed the ruling in Children's Medical Center because the facts in that case are substantially similar to the instant matter. In Children's Medical Center, the administrator received 3 computer-generated billing statements from the medical center 3 months after the decedent's death. In addition, billing statements were routinely sent throughout the decedent's lifetime. These statements included the creditor's name, address, the amount due, indicated the patient's name, and indicated the responsible party as the administrator in her personal capacity. After failure to pay these debts, the medical center filed a lawsuit against the administrator seeking payment. The court ruled that the medical center's presentment through the billing statements was valid under Revised Code 2117.06A1 because the claim was timely sent in writing to the administrator, and because under all of the prevailing circumstances, the notice to the administrator in her personal capacity constituted notice to the administrator in her capacity as fiduciary of the estate. Therefore, the administrator could not have been unaware of the medical center's intention to seek payment from the decedent's estate. Similarly here, David Hudgins was Opal Hudgins' legal guardian during the last years of her life. He knew the bill that she was amassing with Sabre, and because he was responsible for both her medical and financial decisions as her guardian of the estate, he had firsthand knowledge. To suggest that he was unaware of the large amount that was owed to Sabre from Ms. Hudgins' skilled nursing care at that facility is disingenuous. The probate court's failure to consider the arguments that were brought forth in Children's Medical Center and to instead follow a narrow interpretation of 2117.06 constitutes an abuse of discretion. The probate court unreasonably disregarded Sabre's arguments from the beginning, as was evidenced by the probate court's granting David Hudgins' motion to strike only 1 day after it was filed and before Sabre was given the allowable time to respond. Although Sabre was eventually given leave and additional time to file a brief in opposition to the motion to strike, the probate court had already made up his mind and failed to give due deference to Sabre's legal arguments. Therefore, the court acted unreasonably in denying Sabre's claim and granting David Hudgins' motion to strike. So the position that we're in now to ask the question is this: was the intent of Revised Code 2117.06 to create and allow for a loophole which essentially permitted David Hudgins to skirt responsibility for payment? And the law as applied in this case results in the probate court essentially aiding and assisting Mr. Hudgins in his fraudulent avoidance of this valid debt, and he was aware. Fraud is defined as a wrongful or criminal deception intended to result in financial or personal gain. The facts in this case are clear. Opal Hudgins lived at Bath Manor for nearly 18 months during the final years of her life. David Hudgins began that journey as her attorney in fact, but then he took the additional step to become her legal guardian and took the court appointment to be the legal guardian. He put himself out as her legal representative and then sat back and did nothing to help, knowing full well that he was in line to inherit any assets that Ms. Hudgins may have left behind when she passed away. David Hudgins knew that he could benefit, and that is what is being allowed to happen here by what's happening with this decision. David Hudgins should not be allowed to benefit from his actions or inactions, as the case may be, over the course of several years. Further, Mr. Hudgins, has been represented by counsel since Ms. Hudgins became his ward. To claim that he didn't know what he was doing means that he has either been represented by 2 incompetent attorneys prior to Mr. McGargle. I understand he and I have only recently become involved in the case, so I'm not including him with that, or that he took their advice and then essentially acted as the puppet master to create his own puppet show.
Ms. Bachman, just so you know, I tried to tell you before, but I was muted. I apologize. You're into your rebuttal time. You're welcome to continue, but.
Okay, I'm almost finished. Thank you, Your Honor.
Okay.
In doing so, he is spending the estate's money, Opal Hudgins' money, to pay for his legal fees for not 1, but 3 separate attorneys as this wages on. So returning to the intent question, the real question that we have is the legislative intent behind 2117.06. It is most likely that those who created the law that became this section did not intend for estates to avoid paying debts. The intent was not to create a loophole whereby the deceased legal representative during their lifetime, and in this case, a legal guardian, avoided spending the deceased money for the needs of the deceased while they were alive, then later became the estate administrator and created a situation where they inherited it, either by will or by mechanism of law. The intent was likely for timely presentment of the deceased's outstanding debts to a neutral party who then relies on the court to distribute them fairly to outstanding creditors. The situation in this case is unusual in that it allowed the unjust result that we are appealing here today. But Mr. Hudgins not only had actual knowledge of Ms. Hudgins' financial situation prior to her death, he engineered the outcome so that he would directly benefit. It is very doubtful that the unclean hands situation such as this one was the intent when legislators created ORC 2117.06. For these reasons and for those that are outlined more in the appellant's briefs, we request that the court, in this case, follow Children's Medical Center versus Ward and reverse and remand this to the probate court, allowing Sabre Bath Manor's claim to stand as timely and adequately presented to the estate on June 1st, 2018. Thank you.
Counsel,
You're still on mute.
you're muted.
How's that?
Better.
Good.
Thank you, Your Honors. Ralph McGargle for appellee David Hudgins, administrator of the estate of Opal Hudgins. Appellant Sabre Healthcare operates Bath Manor, a residential nursing home in Bath, Summit County, Ohio. Opal Hudgins was a resident of Bath Manor until her death in 2018. David Hudgins is the court-appointed administrator of Opal Hudgins' estate. The narrow issue on appeal in this case is whether the trial court erred in concluding that appellant failed to present his claim to the administrator of the estate of Opal Hudgins after his appointment as administrator and within 6 months of her death, as required by Revised Code Section 2117.06. It is undisputed that no one sought appointment to be administrator of Opal Hudgins' estate for a period in excess of 1 year following her death. That David Hudgins was ultimately appointed administrator, and that David Hudgins and that appellant sent its invoice for Opal Hudgins' care to David Hudgins prior to his appointment and within 6 months of Opal Hudgins' death. Appellant asserts that it complied with the presentation requirements of Section 2117.06 by sending its invoice to David Hudgins prior to his appointment. Appellee asserts that the law strictly required appellant to have presented its claim to him following his appointment as administrator by the probate court and within 6 months of Opal Hudgins' death. Opal Hudgins died on March 16, 2018. David Hudgins was appointed administrator of Opal Hudgins' estate on April 25, 2019. On August 27 of 2019, appellant filed with the trial court its confirmation of waiver to dispute validity of claim. Trial court properly construed that confirmation as being a claim against the estate. Appellee moved to strike or dismiss the claim on the ground that it was time barred. The trial court took briefing on the matter and dismissed appellant's claim as untimely under the statute. It is that decision that is before this court on appeal. Appellant argues that it made its claim to appellee before he was appointed administrator by sending him its invoice within 6 months of Opal Hudgins' death. The law on this issue is clear. Claims against an estate for monies due must be presented to the administrator after his appointment, but before 6 months following the decedent's death. Claims that are not presented within that window are forever barred. This is not the first instance where this issue has been raised. The Ohio Supreme Court ruled on this issue most recently in 2017 in the matter Wilson versus Lawrence, where it held, when the claimant delivers the claim to someone who has not been appointed by a probate court to serve as the executor or administrator of the estate, we hold that the claimant does not meet the statutory requirement. Providing lower courts guidance in construing the provisions of Section 2117.06, the Wilson Court stated, the General Assembly's commands in the statutory scheme were intended to be met with strict compliance. In analyzing the statute, the Wilson Court further stated, Revised Code Section 2117.06's requirement for presenting claims against an estate is a mandatory part of the state's legislative scheme. The specific provisions of Section 2117.06 at issue in this case are subsections A1, B, and C. And the specific language at issue is the legislature's carving out of the window of opportunity within which a creditor must present its claim to an executor or administrator, and the effect of its failing to present its claim within that window. Section 2117.06 states in pertinent part, A, all creditors having claims against an estate shall present their claims, A1, after the appointment of an executor or administrator. B, all claims shall be presented within 6 months after the death of the decedent. C, a claim that is not presented within 6 months after the death of the decedent shall be forever barred as to all parties. As the Supreme Court pointed out in Wilson, each of these requirements is preceded by the word shall, removing any argument of substantial compliance. In applying these provisions to appellant's claim, the trial court cited to In re Estate of Curry, a case directly on point, in which the 10th District Court of Appeals held that a family member who was not appointed administrator of an estate until more than 6 months after the decedent's death was not presented a claim of monies due a nursing home within the time period specified in section 2117.06, regardless of her having been sent and received a bill for that within the 6 months period, but prior to her appointment outside the 6 months. In reaching this holding, the Curry Court stated, strict application of the statutory language to the facts at issue dictates the trial court properly concluded appellant's claim is forever barred because it was not filed within the time required under Revised Code Section 2117.06. Appellant, in its surreply, argued to this court that the facts of Curry differ from those in this matter, stating in its reply brief at paragraph 2, quote, unfortunately for the estate, the factual circumstances in Curry differ from those in the instant matter. In Curry, the court dismissed the presentment of claim because the creditor presented its claim after the 6-month deadline. Unlike in this case, the claim was brought to the administrator after only 2 months of her death. As such, Curry should not be considered precedent, as this critical factual distinction drastically changes the legal analysis of compliance with the statute, close quote. However, appellant's representation of the Curry facts in drawing this distinction was not accurate. In Curry, as here, the claimant nursing home delivered to the person eventually appointed administrator a statement of its claim within 6 months of the decedent's death, but prior to the appointment of that same person as administrator after 6 months. Richard Curry passed away on December 22, 2007. Columbus Healthcare Center delivered its claim to his widow, Audrey Curry Hodge, by letter dated March 10, 2008. Audrey Curry Hodge was appointed administrator in September of 2008. In Curry, as here, the claimant nursing home attempted to cure the defect in its presentment by filing a statement with the probate court that it served the person who was eventually appointed administrator with its claim within the 6-month deadline, but prior to the opening of the estate outside of that deadline. In Curry, Columbus Healthcare Center captioned its late filing statement of claim. Here, appellant captioned its late filing confirmation of waiver to dispute validity of claim. Both Columbus Healthcare Center and appellant presented their invoices to the person ultimately appointed administrator prior to their appointment and within 3 months of the decedent's death. And both argued that sending their claims to the person ultimately appointed administrator within 3 months, but prior to that appointment, that person's appointment outside of 6 months, met the requirement to serve their claims on the administrator within 6 months of the decedent's death. Appellant's revisionist statement of the facts of Curry in its surreply was a misstatement of those facts. No such distinction exists between Curry and the case at bar, and the trial court was correct to cite to it. Appellant argued strenuously that dismissing its claim would be unfair because appellee waited more than 1 year to seek appointment as administrator. But the trial court found that there was a clear path available to appellant when no one stepped forward to open an administration within 6 months of Opal Hudgins' death. Appellant was free to open the estate itself for the purpose of presenting its claim within 6 months of Opal Hudgins' death. Revised Code Section 2113.06c states in pertinent part, if there are no persons entitled to administration, if they are for any reason unsuitable for the discharge of the trust, or if without sufficient cause they neglect to apply within a reasonable time for the administration of the estate, their right to priority shall be lost, and the court shall commit the administration to some suitable person who is a resident of the state. The person granted administration may be a creditor of the estate. Appellant argued at page 15 of its brief that the trial court's statement that appellant could have opened the estate itself within the 6-month period in order to timely assert its claim is against public policy. But this is not against public policy, it is public policy, as clearly set forth by Section 2113.06. The trial court, in its dismissal entry, cited DeRinkle versus Traber, a prior decision of the Ohio Supreme Court, cited favorably in Wilson as laying out appellant's proper course to assert its claim within the 6-month limit, where no administrator stepped forward during that time frame. In Wrinkle, the creditor's claim failed because it did not assert its claim on the estate administrator within 6 months of the decedent's death, as no administrator had been appointed during that time. The Supreme Court held, if this seems to be a harsh result to plaintiff in this instant, it need not have been. Plaintiff had immediate knowledge of the death of the decedent and a course of action to pursue. Under Section 211306 Revised Code, plaintiff had the power to secure the appointment of an administrator within the statutory period of limitation. In fact, plaintiff was aware of this but failed through his own lack of diligence to perfect the appointment. Plaintiff's failure should not lead to the relaxation of what we think should be the sounder rule in such instances, that is, where one has a claim against an estate, it is incumbent upon him, if no administrator has been appointed, to procure the appointment of an administrator against whom he can proceed. Appellant had a clear course of action available to it that, through lack of diligence, it failed to pursue. As the decedent's residential nursing home until her death, appellant was, by necessity, aware of that death. The law concerning presentment of claims is not a secret. Wrinkle was decided in 1963. The instant matter falls precisely within the Supreme Court's sounder rule. Had appellant wished to perfect its claim within the 6 months, it should have sought appointment of an administrator upon whom to present that claim. Instead, appellant sat on its rights to its detriment. Appellant relies on the Second District's 1993 decision in Children's Medical Center versus Ward in support of its position that it timely presented its claim to appellee by sending out its billing statement prior to his appointment as administrator, but within 6 months of Opal Hudgins' death. However, in that case, the decedent, Monte Sabre, died on April 25th, 1990. The administrator, Tammy Ward, was appointed on May 8th, 1990, and Children's Medical Center, the creditor, sent its invoice to Ward after her appointment and within 6 months of the decedent's death. In the Second District syllabus, Judge Fain specifically sets forth 3 criteria for a valid presentment of claim. It must, 1, clearly indicate the creditor's name, address, and the precise amount of the obligation due. 2, identify the decedent as the debtor, and 3, be timely received by the administrator of the decedent's estate. It is, of course, this third criteria that renders Children's Medical Center inapposite to appellant's claim. For these reasons, appellee respectfully requests that the court uphold the trial court's decision in dismissing or striking appellant's claim against the estate of Opal Hudgins. Thank you, Your Honors.
All right, thank you. Ms. Bachman, you have 52 seconds.
Thank you, Your Honor. I'd just like to reiterate that the intent behind what we're talking about here today is what's at issue. And when these claims were presented on June 1st, 2018, and actually up until August 1st of 2019, David Hudgins was still Opal Hudgins' guardian. Even though she passed away in March, he never resolved that situation or closed that case until well over a year later, after he was appointed as administrator well after the fact. So when Sabre gave their final bill, if you will, their proof of claim to Mr. Hudgins in June 2018, he was the only person who was available at that time. He was the one who was in control of her finances. He was the one who was responsible. Why didn't Sabre go forward and make their own estate and set themselves up? Well, because they're a skilled nursing care facility. They were in communication with Mr. Hudgins, so they thought they had provided information. They are not in the business of setting up a state in order to go after them. So as for why that happened, I don't have the answer for that, except that they had a person they were talking to, a person who was responsible up until the end of 2018. excuse me, as her guardian well after the fact. And so it was their position that he was responsible and should pay, had been responsible the entire time and
Okay,
should pay on.
I don't want to cut you mid-sentence, but you're well past your time now. All right, thank you both for your arguments. We'll take the matter under advisement, issue a written decision in due course. It will be mailed to both sides as well as posted on our website and on the website of the Ohio Supreme Court. Both of you have a good day.
Thank
Thank
Your
you.
Honor.
Thank you.